Good afternoon. My name is Kim Stanger. I'm the head of Holland & Harris Health Law Group. We are here to talk today about HIPAA and disclosures to family and friends. HIPAA is a big part of my practice, and I thought that it might be well to review some of these rules because I get a lot of questions from clients and others about, when can I talk to family and friends? What are the conditions on which I can disclose information to family and friends? Hence the webinar. A few preliminaries. We're going to be talking today about situations in which HIPAA allows disclosures, including personal representatives, families and others involved in the care, and so forth. As far as written materials, you should have received a link that contains some written materials, including a copy of the PowerPoint slides, some publications by the Office for Civil Rights, and then a few client alerts that I've done on different HIPAA issues that may be relevant to the things we're talking about today. The presentation will be recorded and available in case you want to use it for training or anything else, along with our other webinars. Those are all on our Health Law blog. They're all free, so you can use them as you see fit. In addition, if you have questions going through the program today, you can submit those to me using the chat feature. I probably won't have time to take them during the presentation, but I can respond offline. Or you can shoot me an email at the address that I put in the slides or in the chat feature. With that said, let's talk about HIPAA. HIPAA is the Health Insurance Portability and Accountability Act of 1996. It's all found in 45 CFR Section 164. You've got the privacy rule, the security rule, and the breach notification rule. Of course, they also came out with the security rule, but we're really focusing today on the privacy rule issues. When we're talking about HIPAA, remember I'm just focusing on HIPAA today, to the extent that there are more restrictive state or federal laws, then you've got to comply with those more restrictive laws. HIPAA is kind of the floor to patient privacy. So if there's a more restrictive law, you got to comply with that more restrictive law. If there's a less restrictive state law, then you've got to comply with at least HIPAA. For example, if you're dealing with records concerning a federally assisted drug or substance use disorder program, then you've got to comply with 42 CFR Part 2 in addition to HIPAA. And coincidentally, I'm actually going to be addressing 42 CFR Part 2 in a webinar a couple of weeks from now. Why do you have to comply with HIPAA? Well, in bad cases, you can actually go to jail. That doesn't occur all that often. More often, you as healthcare providers need to be concerned about the civil penalties that can be imposed, anywhere from $112 to $55,000, about $56,000 per violation. That's bad. What's really bad is it's a mandatory fine of at least $11,000 to $56,000 per violation if you act with willful neglect. And it's really, really bad if you act with willful neglect and fail to correct it within 30 days. The penalty is at least $56,000 per violation. So you want to make sure when you're dealing with HIPAA disclosures to family or others that you don't act with willful neglect. Hopefully these rules in our discussion will help you do that. In addition to those penalties imposed by the Office for Civil Rights, the State Attorney General can bring lawsuits. In the future, individuals may actually be able to recover a percentage of those fines and penalties that are levied against you. Just a word of caution on that. The buzz out there is that we may be seeing before too awfully long these regulations that implement the HITECH Act provisions that allow individuals to recover a percentage of those fees. So you may want to watch out for that. If you've got an employee that violates HIPAA, you've got an affirmative obligation to sanction that employee, or else you could be in violation of HIPAA. You, of course, have an obligation to self-report breaches of unsecured protected health information to the individuals, to HHS, and sometimes local media. And it's possible that you could get sued. Even though there is no private cause of action under HIPAA, you see a lot of lawsuits out there where they're using HIPAA as a standard of care or a violation of confidentiality to bring some kind of state law towards. So that's why you need to comply. Let's talk about what you need to do to comply when talking about disclosures to family and friends or others involved in the patient's health care. These are the situations generally that allow you to make disclosures. Each of these different situations have different rules. We're going to go through them relatively quickly. You may have a situation where you can make disclosures because the person is the personal representative. There's another exception that allows you to make disclosures to family or others involved in the health care if certain conditions are satisfied. There's rules concerning disclosures for deceased persons, facility directories. You can make disclosures for certain treatment, payment, or healthcare operations to avert a substantial harm as required by law, or if you don't fit with any of the foregoing exceptions, you can make disclosures if you're requested to make that disclosure by the individual in writing or you have a written authorization. Okay, let's talk about each one of those now. First and foremost, most importantly, is the personal representatives. Under HIPAA, you may, indeed you must, disclose protected health information to personal representatives. Under HIPAA, you treat the personal representative as if they were the individual. That means that just because an individual usually, or just as an individual usually has a right to access their own information, the personal representative has the right to access the patient's information subject to certain limitations. So then the question is, okay, well, who is a personal representative for purposes of HIPAA? Well, if you're talking about an adult patient or an emancipated minor, in that situation, HIPAA defines the personal representative as the person who has authority to act on the behalf of the patient under applicable state law. So you'd have to look at your state law to determine who has the authority to make health care decisions for that patient. If that person has the authority to make health care decisions, generally under HIPAA, then they are also the person who has the authority to make decisions concerning information about their health care. They are their personal representative for purposes of HIPAA. In the case of unemancipated minors, similar rule. The personal representative is the person who has authority to make decisions for the minor's health care unless, so general rule is if they've got the authority to make decisions concerning the minor's health care, they are the personal representative and they have a right to access the information and you may disclose it to them. Unless you do not treat this person as the personal representative if the minor can consent to their own health care. Well, if they can consent to their own health care, then that other person does not have, or doesn't really have the authority to make the health care decisions for the minor because the minor can consent to their own health care and therefore they are not the personal representative. That could be a situation where maybe a statute allows the minor to consent to their own health care for maybe STDs, maybe for certain substance abuse treatment or other situations, maybe contraceptives in those situations. So you may have to be careful of disclosing information to a parent if that information concerns the minor's treatment for certain conditions that the minor can consent to their own health care. Next exception is if the law doesn't require the consent of another person and the minor consents, then you don't treat that other person as the personal representative. Next, if the parent or authorized surrogate agrees to confidentiality between the patient and the minor, then you can agree not to, or you can decide not to treat that parent or other surrogate as the personal representative. So it may be a situation where a parent brings in her 16-year-old daughter. The parent knows that the daughter is not going to make disclosures to the physician if the minor knows that the physician is going to make those disclosures to the parent. So the parent tells the physician, hey, you can keep this information confidential. In that situation, the healthcare provider does not need to treat the parent as if they were the individual. Now, there's kind of this general caveat when it comes to these personal representative situations that HIPAA in large part defers to state law. So under HIPAA, the provider may disclose or withhold information from a parent or surrogate to the extent that's allowed by state law. So if you have a specific state law that either requires disclosure to parents despite what's in these HIPAA provisions or that prohibits you from making disclosures, then generally that more restrictive state law will apply. In the OCR's recent guidance concerning the opioid crisis, they give the following summary, which is a pretty good summary of the rule for personal representatives. HIPAA recognizes a patient's personal representatives according to state law. Generally, HIPAA provides a patient's personal representative the right to request and obtain any information about the patient that the patient could obtain, including a complete medical record. The personal representatives are persons who have health care decision-making authority for the patient under state law. This authority may be established through the parental relationship between the parent or guardian of an unemancipated minor, or through a written directive, health care power of attorney, appointment of a guardian, a determination of incompetency, or other recognition consistent with state laws to act on behalf of the individual in making healthcare-related decisions. So, general rule is, if the person has the authority to make healthcare decisions for the individual, then in that situation, that person is the personal representative. You can, indeed, you must disclose the information to them if they request access to that information. Now, there are some limitations on that. You are not required to treat that personal representative as if they were the patient, meaning that you don't disclose the information to them and they don't have a right to access the information if the minor has the authority to consent to their own health care. We already talked about that. Or if the minor obtains care at the direction of a court or a person appointed by the court. In that situation, that person, the personal representative, isn't making the health care decisions, it's this court-appointed person. Or if the patient agrees that the provider may have a confidential relation, or the parent agrees that the provider may have a confidential relationship, like we talked about. Or if the provider determines that the treating personal representative as the patient is not in the best interest of the patient. For example, it may be an abuse situation where the father is, you suspect that they are abusing the minor patient. Father may come in and request access to those records. Normally he would be considered the personal representative, but this exception would allow you to say, notwithstanding anything else in state law, that you are able to decline to provide that information to the father or treat the father as if they were the personal representative if you think it's not in the best interest of the patient. In addition, under the patient's general right of access under 45 CFR 164.524, under the general rules, you can deny access to the patient and therefore to the personal representative under certain circumstances. If the information sought is outside the scope of the designated record set, a patient or their personal representative generally do not have the right to access information outside the designated record set. The designated record set, of course, are those records that you use to make decisions concerning the patient, their health care, their payment for their health care, or the like. It would not be other records that are unrelated to decisions concerning the patient's health or health care. For example, peer review records, quality assurance records, those types of things generally are not within the designated record set. Next, you may deny access if there's a request to access psychotherapy notes. Psychotherapy notes get extra protection. Patients or their personal representatives generally are not entitled to that. You can deny access to the personal representative or patient if the information was obtained under a promise of confidentiality and the disclosure would identify the source of that information, or if the information was compiled in anticipation of civil, criminal, or administrative actions or proceedings, or if the information was concerns an inmate, if it would endanger the patient or others for research purposes, or if the licensed provider has determined that access is reasonably likely to endanger the patients or others. Now, this last situation, if you decide not to give the information to the personal representative or the patient because you think that that information is likely to endanger the patient or others, in that situation you have to notify the patient or personal representative and give them a right to have that decision reviewed, and then that decision would be reviewed by a third party that you identify. So those are situations where you can decline to provide access to the personal representative. But the general rule is the personal representative has the right to access information, therefore you can disclose information to the personal representative without the patient's authorization. Okay, that's the first and perhaps most important exception when dealing with family members. The next is HIPAA says that you may use or disclose protected health information. You can disclose it to family members or others involved in the patient's health care or payment for their care, depending on the circumstances. If the patient is present and otherwise competent, able to consent or object, you may disclose if the patient agrees to the disclosure or has a chance to object and does not object, or it's reasonable to infer agreement from the circumstances. So, for example, the patient's in there, the patient decides to bring in their significant other back into the exam room. You could infer from those circumstances that the patient doesn't care if that significant other hears what's going on. So you could make the disclosure and that would not violate HIPAA. Now, those are situations if the patient is present and able to agree. In general, you're supposed to either get the patient's agreement or give them the opportunity to object. And if they haven't objected, then you can go ahead and make the disclosure. Well, what about if the patient is not present or is otherwise not able to agree? Maybe they're incompetent or whatever. In that situation, you may disclose the information if the patient has not objected in the past, so the disclosure would not be inconsistent with their prior expressed wishes, and you determine that it's in the best interest of the patient. Now, in either of those cases, you can't disclose all information about the patient. You can only disclose the information that's related to that family member's or other person's involvement in the patient's health care. In the wake of the omnibus rule, this rule about disclosures to family members and others involved in the patient's health care was also extended to deceased persons. It used to be for deceased persons you could only disclose the information to the personal representatives or as authorized by the personal representative. The omnibus rule amended that or added this additional one, so as long as the patient did not tell you while they were alive that they don't want this family member or other person involved in their care to get the information, then you can go ahead and disclose the information to that family member as long as it's consistent with the expressed wishes of the deceased patient while that deceased patient was alive. The OCR has issued some frequently asked questions that talk about this. I thought it might be well to just briefly summarize those. So here's one of the FAQs. It says, does the HIPAA privacy rule permit a doctor to discuss a patient's health status, treatment, or payment arrangements with the patient's family or friends? Yes. If the patient is present or is otherwise available prior to the disclosure and has the capacity to make healthcare decisions, the covered entity may discuss this information with the family and these other persons if the patient agrees or, when given the opportunity, does not object. The covered entity may also share relevant information with the family and these other persons if the covered entity can reasonably infer, based on their professional judgment, that the patient does not object. Under these circumstances, for example, a doctor may give information about a patient's mobility limitations to a friend driving the patient home from the hospital. That could also come under treatment, by the way. A hospital may discuss a patient's payment options with her adult daughter. A doctor may instruct a patient's roommate about proper medicine dosage when she comes to pick up her friend from the hospital. Or a physician may discuss a patient's treatment with the patient in the presence of a friend when the patient brings the friend to a medical appointment and asks the friend if the friend can come into the treatment room. So those are some examples. The key there is if the patient is present and competent, you either get the patient's agreement or at least give them the opportunity to object, and they don't object to making that disclosure, and you otherwise think it's reasonable under the circumstances. In the that guidance that they issued on the opioid crisis, they give the following. HIPAA respects individual autonomy by placing certain limitations on sharing health information with family members, friends, and others without the patient's agreement. For patients with decision-making capacity, a healthcare provider must give a patient the opportunity to agree or object to sharing health information with family, friends, and others involved in the individual's care or payment for care. The provider is not permitted to share health information about patients who currently have the capacity to make their own healthcare decisions and object to sharing the information generally or with respect to specific people unless there is a serious and imminent threat of harm to health as described. Actually, we'll talk about that later, as described below. So the general rule then, the patient is present, able to make decisions, has decision-making capacity, then you would generally ask the patient or make sure that you give the patient the opportunity to object, and they decline to object. So here's a question for you. In your Notice of Privacy Practices, do you have this exception listed in your Notice of Privacy Practices that says something to the effect of, hey, we may disclose your protected health information to family members or others involved in the patient's health care so long as you don't object? Is that sufficient? Does that give the patient sufficient notice so that they can tell you if they don't want you to do that? Personally, I think that that probably is sufficient. I mean, that's why you give them the Notice of Privacy Practices, right? Is to tell them that this is what you can do. With that said, you know, the government may disagree. I don't think it would be willful neglect, so I don't think that you would be penalized for doing that. But if you really wanted to be safe, if you want to know whether you can disclose the information to family members and the patient there, then simply ask the patient and or give them the opportunity to object, and if they don't object and it's otherwise reasonable, then you can go ahead and make the disclosure. All right, well, what about the situation when the patient is not present? That FAQ goes on to say, even when the patient is not present or it is impracticable because of emergency circumstances or the patient's incapacity for the covered entity to ask the patient, the covered entity may share this information with the person when, in the exercising professional judgment, it determines that doing so would be in the best interest of the patient. Thus, for example, a surgeon may, if consistent with such professional judgment, inform a patient's spouse who accompanied her husband to the emergency room that the patient has suffered a heart attack and provides periodic updates on the patient's progress and prognosis. Or a doctor may, if consistent with such professional judgment, discuss an incapacitated patient's condition with a family member over the phone. So if the patient is unable to agree or object, in that situation you can go ahead and make the disclosure so long as that disclosure is not inconsistent with the patient's prior expressed wishes and you otherwise deem it to be reasonable in the exercise of professional judgment. Again, the guidance from the recent opioid crisis memo, HIPAA allows healthcare professionals to disclose some health information without a patient's permission under certain circumstances, including sharing health information with family and close friends who are involved in the care of the patient if the provider determines that doing so is in the best interest of an incapacitated or unconscious patient and the information shared is directly related to the family or friends' involvement in the patient's health care or payment for their care. For example, a provider may use professional judgment to talk to the parents of some incapacitated by an opioid overdose about the overdose and related medical information, but generally could not share medical information related to the overdose without permission. Could not share medical information unrelated to the overdose without permission. Key there is even if HIPAA would allow you to make the disclosure under this particular exception, make sure you limit the scope of that disclosure to that person's involvement in the patient's health care. Again, the OCR's FAQ states, what about situations where maybe somebody shows up to pick up the patient's records or the patient sends somebody to go pick up their prescription? Can you provide information or that prescription to that other person? That generally can fit within this exception about family members or others involved in the patient's health care. Again, the FAQ states, the privacy rule expressly permits a covered entity to use professional judgment and experience with common practice to make reasonable inferences about a patient's best interest in allowing another person to act on behalf of the patient to pick up a filled prescription, medical supplies, x-rays, or other similar forms of protected health information. For example, when a person comes to a pharmacy requesting to pick up a prescription on behalf of an individual he identifies by name, a pharmacist, based on professional judgment and experience with common practice, may allow the person to do so. So that's a situation where the patient's not present, and therefore, in order to be able to provide that, make that disclosure, the pharmacist or other healthcare provider would have to make sure that such disclosure is not inconsistent with the patient's prior wishes, that the patient hasn't previously objected to such disclosures, and the pharmacist or healthcare provider would have to determine that in their professional judgment it's okay, it's reasonable, it's appropriate to go ahead and provide that information to that particular individual. Well, what about if a patient shows up at your hospital and you want to know whether or not you can notify family members that that patient's down there at the hospital? The HIPAA FAQ says, yeah, you can go ahead and do that. The HIPAA privacy rule permits covered entities to notify family members, personal representatives, or other persons responsible for the care of the patient's location, general condition, or death. That's the facility exception. Where the patient is present or is otherwise available prior to the disclosure and has capacity to make healthcare decisions, the covered entity may notify family and these other persons if the patient agrees, or when given the opportunity does not object. Okay, that's that first exception. On the other hand, the covered entity may also use or disclose this information to notify the family and these other persons if it can reasonably infer from the circumstances based on professional judgment that the patient does not object. So even if the patient's not present or is incapacitated, then you can still go ahead and make the disclosure so long as it's not inconsistent with the patient's prior directions and you determine that it's reasonable under the circumstances. So, under these circumstances, for example, a doctor may call a patient's wife to tell her that her husband was in a car accident and is being treated in the emergency room for minor injuries. Or a doctor may contact a pregnant patient's husband to let him know that his wife arrived at the hospital in labor and is about ready to give birth. Or a nurse may contact the patient's friend to let him know that his roommate broke his leg falling down the stairs, has had surgery, and is in recovery. Okay. So, in implementing this particular exception, which generally, if the patient's capable, competent, and present, then you have to generally either ask for their permission or at least give them the opportunity to object, and the patient can't object or doesn't object. You know, should you be asking the patient for a list of persons to whom you may disclose the information? Well, the benefits, of course, then you're documenting that the patient has agreed, right? That you can contact those people. I'm always a little bit leery about when the patient just comes in that you say, okay, here's this list, identify everybody that we can make disclosures to. Because that list may not be all-inclusive, and there may be circumstances you want to make disclosures to other persons. So if you are going to have the patient sign some kind of a list of all of those persons to whom you may make disclosures, make sure that that list is not exclusive. Make sure the patient understands that in addition to these people, we may be able to make disclosures to other persons consistent with HIPAA requirements, for example, to payers or other persons. My concern is if you just give them that list, it may create this negative inference that these are the only people that we can make disclosures. So if you're going to use that list, include some kind of disclaimer on the bottom that says, and we reserve the right to make disclosures to anybody else, consistent with our notice of privacy practices and applicable HIPAA rules, something to that effect. All right, so that's the second exception to allow you to make disclosures. First exception, you can disclose to personal representatives. Second exception, you can disclose to family members and others involved in the patient's health care, so long as the patient agrees or hasn't objected and it's otherwise reasonable under the circumstances. Third exception, you can make disclosures to the extent it is for treatment purposes. That's that general treatment, payment, and healthcare operations, right? HIPAA says you can make disclosures for treatment purposes without the patient's authorization. You can make those for your own treatment purposes or for another healthcare provider's treatment purposes, unless you've agreed otherwise with the patient. I'm going to come back to that in a minute. But what is treatment? Treatment is very broad. It's defined as the provision, coordination, or management of healthcare and related services by one or more healthcare providers, including the coordination or management of healthcare by a healthcare provider with a third party, consultation between healthcare providers related to a patient, or the referral of a patient for healthcare from one healthcare provider to another, or anything else that constitutes treatment. So long as that disclosure is for treatment purposes, you can go ahead and use it and disclose it, even if the patient hasn't agreed to it or hasn't accepted it. Remember, this is a separate exception, separate and apart from that disclosure for family members or others involved in the patient's health care. Now, this disclosure for purposes of treatment does not apply to psychotherapy notes. Psychotherapy notes get special protection under HIPAA. But what about leaving messages with others at home? How does that apply? Well, that kind of fits within this whole treatment exception. There's an FAQ specifically on this situation. The OCR said, here's the question, may physicians' offices leave messages for patients at their homes, either on an answering machine or with a family member, to remind them of appointments or to inform them that a prescription is ready? Or may providers continue to mail appointment or reminders to patients' home? The answer, yeah, sure, you can go ahead and do that. It's for treatment purposes. The HIPAA privacy rule permits the healthcare providers to communicate with patients regarding their health care. This includes communicating with patients at their homes, whether through the mail or by phone or in some other manner. In addition, the rule does not prohibit covered entities from leaving messages for patients on their answering machines. However, you've got to put in place reasonable safeguards. To reasonably safeguard the individual's privacy, covered entities should take care to limit the amount of information disclosed on the answering machine. For example, a covered entity might want to consider leaving only its name and number and other information necessary to confirm an appointment or ask the individual to call back. You don't want to leave the message that the HIV test came back positive. Going on, the FAQ states a covered entity may also leave a message with a family member or other person who answers the phone when the patient is not home. Again, the disclosure is for purposes of treatment. The privacy rule permits covered entities to disclose limited information to family members, friends, or other persons regarding an individual's care, even when the individual is not present. However, the covered entity should use professional judgment to assure that such disclosures are in the best interest of the individual and limit the information disclosed. What about if the patient tells you that they want the message sent to their home, they want their message, their report reminder sent to some other location? Then, according to the OCR and the HIPAA rules, in situations where a patient has requested that the covered entity communicate with him in a confidential manner, such as by alternative means or an alternative location, the covered entity must accommodate that request, if reasonable. For example, a request to receive mailings from the covered entity in a closed envelope rather than by postcards is a reasonable request that should be accommodated. Similarly, if the patient tells you don't send this information to my home or don't leave a message on my answering machine, you generally need to accommodate that. Similarly, a request to receive mail from the covered entity at a post office box rather than at home or to receive calls at the office rather than at home are also reasonable requests absent extenuating circumstances, and you would need to comply with those. Okay, well, HIPAA allows you to make disclosures then for purposes of the patient's treatment. What about for purposes of treating others? So this particular physician isn't disclosing information about a patient they're treating, but they want to disclose, or they're asked to disclose information that's relevant to another person's treatment, maybe another family member. Can you make that disclosure? Well, there's an FAQ. Yes, FAQ says, under the HIPAA privacy rule, may a healthcare provider disclose protected health information about an individual to another provider when such information is requested for the treatment of a family member of the individual? And the answer is yes. It's still for treatment purposes. The HIPAA privacy rule permits a covered healthcare provider to use or disclose protected health information for treatment purposes. While in most cases the treatment will be provided to the individual, the HIPAA privacy rule does allow the information to be used or disclosed for the treatment of others. So for example, you get your sister's doctor calls to get information about you that may be relevant to that sister's treatment, maybe your medical history, whether there's some kind of family history of a certain condition. Then your treating provider could disclose that information to that other healthcare provider so long as it's represented that that information is for treatment purposes of another person. Thus, the rule does prohibit a doctor to disclose protected health information about a patient to another healthcare provider for the purposes of treating another patient, for example, to assist the other healthcare provider with treating a family member of the doctor's patient. All right, so that's another exception that applies, as long as the disclosure is for purposes of treatment. Now, that only applies if and to the extent you haven't agreed otherwise with the patient. 45 CFR 164.524 says that you can, a patient has a right to request additional restrictions on the use or disclosure for purposes of treatment, payment, or healthcare operations. And if you agree to those additional restrictions, you have to comply with them. That means that even though HIPAA would allow you to go ahead and make disclosures for purposes of treatment, payment, or healthcare operations without the patient's authorization, if you agree with the patient that you won't make those disclosures, even though HIPAA would otherwise allow it, then you're bound by that. My advice to you is don't ever agree to those restrictions. If you do, you're only going to limit your ability to make disclosures and expose yourself to liability. All right, so the first exception is treatment. The second exception under that particular rule is payment. You can, again, just like any other situation, you may disclose protected health information for your own payment purposes or for the payment purposes of another covered entity, unless, again, you've agreed otherwise with the patient. Payment, again, is construed very broadly. It's defined very broadly. It includes to obtain reimbursement for the provision of health care, including billing, collecting, obtaining payment, determining coverage, pre-authorization, justification of charges, limiting disclosures to consumer reporting agencies, or whatever else, as long as it's for purposes of payment. Again, that does not apply to psychotherapy now. So you may have a situation where patient comes in, they get care, you provide care to the patient, but you expect to get paid by the parent. Can you make disclosures to the parent in order to get paid? Well, there's actually an FAQ on that. Does the HIPAA privacy rule permit a covered entity or its collection agency to communicate with parties other than the patient, for example, spouses or guardians, regarding the payment of a bill? And the answer is, yeah, as for payment purposes. The privacy rule permits a covered entity to disclose protected health information as necessary to obtain payment for health care, and does not limit to whom such disclosure may be made. Therefore, a covered entity may contact persons other than the individual as necessary to obtain payment for health care services. So if the patient doesn't pay and you need to go after their parents in order to collect, then this would allow you to do it. However, the privacy rule requires a covered entity or its business associate to reasonably limit the amount of information disclosed for such purposes to the minimum necessary, as well as to abide by any reasonable request for confidential communications and any agreed to restrictions on the use or disclosure of protected health information. So you could go after the parent, you could contact the parent to make sure you get paid, so long as you only disclose the minimum necessary and you have not otherwise agreed with the patient that, hey, we're only going to disclose this information to the people you authorize us to disclose the information to. So be very careful about making those agreements to restrict your ability to disclose. Well, what about healthcare operations? Under HIPAA, you may disclose protected health information for certain healthcare operations, your own healthcare operations. But what about if you want to make the disclosure, or somebody's asked you to make the disclosure for that other entity's healthcare operations, where the rules are more restrictive there? You can only disclose the information to another entity for their healthcare operations if both entities have a relationship with the patient and the disclosure pertains to such relationship, and the disclosure is for certain purposes listed in the definition of healthcare operations. Generally, you can only disclose to another entity for that other entity's healthcare operations if those operations deal with conducting quality assessment or improvement activities, population-based activities relating to improving healthcare, contacting patients about treatment alternatives and related functions that did not include treatment, or reviewing the competence or qualifications of healthcare professionals, evaluating the practitioner and provider performance, and so forth. Those are the situations that would allow you to make disclosures for another covered entity's healthcare operations. As I mentioned, for those exceptions for treatment, payment, or healthcare operations, those only apply if and to the extent you have not otherwise agreed with the patient that you'll keep that information confidential. So don't agree with the patient to keep that information confidential, or that you won't disclose the information to other persons. Never agree with the patient to limit your disclosures to only certain people. Make sure that you reserve your right to disclose the information if and to the extent allowed by HIPAA for purposes of treatment, payment, or healthcare operations. All right, those are other exceptions that allow you to make disclosures to family members. Under HIPAA, you may also make disclosures to the extent that the disclosure is required by law. For example, certain laws may require the provider to disclose certain information to family members. Most states have a statute out there that if you, as a healthcare provider, become aware that the patient has made credible threats against another individual, then this statute would require you to make disclosure to that other individual or law enforcement, or if it's a minor, to the minor's family. So if one of those laws applies, HIPAA allows you to go ahead and make the disclosure. Just make sure you limit the scope of that disclosure to the information that is required by law. Under a separate exception, HIPAA allows you to use or disclose protected health information if you determine in good faith that you believe the use or disclosure is necessary to prevent or lessen a serious and imminent threat to the health or safety of a person or the public, and that disclosure is to a person or persons reasonably able to prevent or lessen the threat, including the target of the threat. So if you've got a situation where a patient comes in, you think that they are posing serious and imminent threat to themselves or others, then you might be able to, then you can, under this exception, contact, for example, family members in order to help avert that threat. You may contact another person who's the target of that threat to maybe alert them to that particular threat. A covered entity is presumed to have acted in good faith if that belief that there's this serious and imminent threat of harm is based upon the covered entity's actual knowledge or in reliance on a credible representation by a person with apparent authority. So this is another catch-all exception that allows you to make disclosures to family members or others if it's necessary to avert a serious threat. In that opioid memo, the OCR explained it as follows. HIPAA allows healthcare professionals to disclose some health information without a patient's permission under certain circumstances, including informing persons in a position to prevent or lessen a serious and imminent threat to the patient's health or safety. For example, a doctor whose patient has overdosed on opioids is presumed to have complied with HIPAA if the doctor informs family, friends, or caregivers of the opioid abuse after determining, based on the facts and circumstances, that the patient poses a serious and imminent threat to his or her health through continued opioid use upon discharge. Finally, there's also that exception that allows you to use or disclose information for purposes of a facility directory. This isn't limited to just family and friends, it's anybody. If you maintain a facility directory and a patient somebody comes there to ask if the patient's there at the facility, then generally you can disclose limited information to them if certain conditions are satisfied. You can disclose limited information for purposes of that facility directory if you gave the patient advance notice and the patient does not object. For example, you told them in your notice of privacy practices that you would use their information for a facility directory unless they object, and they didn't object, and the requester has to ask for the patient by name. So you can only disclose the information about that particular patient if, under this exception, if the person who asks about the patient by name. If the patient's unable to agree or object, you may use or disclose the limited information for directory purposes if it's consistent with the patient's prior decisions and you otherwise determine that it's in the patient's best interest. But for purposes of this facility directory exception, that disclosure, you can only disclose limited information, including the person's name, but of course the person who asked for the patient already has their name because they had to ask for the patient by name. You can only disclose their location in the facility, their general condition, and if it's a minister who asks for the patient by name, you could disclose their religion. This is a separate exception other than those that we've already talked about, but this is an exception that will allow you to make disclosures to family, friends, or others who ask for the patient by name, so long as the patient hasn't otherwise objected. All right, those are exceptions that allow you to make the disclosures without the patient's authorization. If you can't fit within one of those exceptions, or you don't feel comfortable fitting within one of those exceptions, because HIPAA generally, with the exception of disclosures to the individual or disclosures to personal representatives, HIPAA doesn't require you to make the disclosure, it just says that you may. Even if HIPAA would allow you to make the disclosures, you may, if you wanted to, require a written authorization or a written request from the patient. Under the omnibus rule, it used to be that to disclose to a third party, you generally needed the patient's written authorization. That authorization had to contain certain elements. But in the omnibus rule, they said, well, wait a minute, a patient has a right to access their information. We think that right to access also means a right that the patient has to go ahead and direct you to provide that information to a third party. That's part of the right of access. So you must provide protected health information in a designated record set to a third party if you get a written request by the patient that clearly identifies the designated recipient and where to send the information and is signed by the patient. Note that this does not require all the elements in a formal HIPAA authorization. If you just simply have a note from the patient saying, hey, I want you to disclose this information to so-and-so at such and such address and it's signed by the patient, then you would need to go ahead and make that disclosure if that information is within the patient's designated record set. Now, this is all part of the individual's right to access. That means that the rules applicable to the individual's right of access also apply to these types of requests, meaning that you have to generally respond within 30 days. You can only charge a reasonable cost-based fee, just like as if the individual were requesting that access. So if the patient comes in and says, hey, I want you to send my mom this information, or I want you to send my friend this information, then you are obligated to go ahead and comply with that request unless you can fit within one of the exceptions that would allow you to deny the patient's access to the information. Alternatively, if the request is initiated by a third party rather than the patient, then you would need to comply with the HIPAA authorization rules unless you can fit within a different exception. That means that you need a written authorization for certain types of disclosures, including psychotherapy notes, marketing, sale of protected health information research, and for other uses or disclosures unless a regulatory exception applies. And that authorization generally has to contain certain elements. It has to contain certain statements, certain elements such as identifying the purpose of the disclosure, the entity making the disclosure, the entity to whom the disclosure is made, has to contain a termination date or event, and so forth. If you don't have all of those required elements in your authorization, then technically it's invalid. Now, if that authorization originated with the patient, it's not necessary to satisfy all those because, remember, the patient can go ahead and simply request that you provide the information per their written request, and that would suffice under HIPAA. But if you are relying on the authorization exception, then you would need to make sure that your authorization complies with those additional technical requirements. All right, real briefly, in those situations where HIPAA will allow you to make the disclosure, you still got to comply with a couple of rules. The first is the minimum necessary standard. General rule is that you can only disclose the minimum necessary for the purposes of the permissible disclosure. If it's a disclosure to the individual or their personal representative, then the minimum necessary standard generally does not apply. But if it's a disclosure to family members or others under one of those other exceptions, then you've generally got to limit your disclosure to the minimum necessary. In addition, before you make that disclosure, you need to take reasonable steps to verify that the person is who they are and that they're entitled to the information if you don't know them. For example, if Johnny's mom calls in and says, hey, I want to get Johnny's record, you would make sure that that really is Johnny's mom. For example, you may ask for information that would, only the parent would know, things like the patient's date of birth, social security number, last date of treatment, maybe ask for the person's identification, ask for a document confirming that the person is the guardian agent, person with the agent or so forth. The OCR, again, has issued an FAQ on this issue. If a patient's family member, friend, or other person involved in the patient's care or payment for care calls a healthcare provider to ask about the patient's condition, does HIPAA require the healthcare provider to obtain proof of who the person is before speaking with them? No, not per se proof, but you do have to verify that they are who they say they are by taking reasonable means. They go on to answer the question. If the caller states that he or she is a family member or friend of the parent or is involved in the patient's care or payment for care, then HIPAA doesn't require proof of identity in these cases. However, the healthcare provider may establish his or her own rules for verifying who is on the phone. In addition, when someone other than a friend or family member is involved, the healthcare provider must be reasonably sure that the patient asked the person to be involved in his or her care or payment for the care. Just a word about patient portals. You guys are all actively engaged in your patient portals, I assume. Well, that can create problems in providing access, especially if your patient is a minor and the parent wants to access it, or a third party wants to access that. Just remember that the rules concerning portal access are more narrow than patient access. You don't have to give access to all of the patient's records in their designated record set through the patient portal. You might create subcategories or only provide access to certain information through the patient's portal. Remember, you may, under HIPAA, you may limit access to the information if it's not part of the designated record set or psychotherapy notes. Patients aren't entitled to that. Or the information is obtained under a promise of confidentiality, or the access may cause substantial harm to the patient or other person. That's the rules under HIPAA. But when it comes to the patient portal, you can actually kind of set up your own rules. You can decide what information you're going to disclose through the patient portal and which information you're not. You may want to create some kind of process internally to flag or limit access to certain types of sensitive records. For example, some state laws may provide additional protections beyond HIPAA for certain types of confidential information, maybe HIV or STDs, mental health records, substance abuse records, genetic tests. In those situations, your state law or other law may limit the ability of third parties to access that information. You want to make sure that your patient portal is set up appropriately to block their access to information to which they're not entitled. When it comes to access by personal representatives, remember the personal representative generally has the right to access all the information, but you don't treat the personal representative as if they were the individual in certain circumstances, including cases where the minor can consent to their own health care. So you have to be careful about allowing the personal representative to access all of the information without the patient's authorization if the patient can consent to their own health care. So in general, you may or should deny personal representative access if the minor reaches the age of majority, because then that personal representative is no longer the personal representative because the minor the now adult, can make their own health care decisions. So you would need the patient's authorization to be able to allow that parent to go ahead and access that information as a general rule. Or you may deny access if the patient may consent to their own care under state law. For example, maybe the minor under state law has the authority to consent to their own health care to get treatment for certain sexual transmitted diseases, drug or alcohol treatment, mental health care, reproductive health, those types of issues. If the minor can consent to their own health care, then you need to be very careful about allowing a personal representative or a parent to access that information, because if the minor can consent to their own health care, the parent is not the personal representative for those episodes of care. So you can't rely on the personal representative exception to allow the parent to access that information. You'd have to have a different HIPAA exception to allow them to access that record through the patient portal. So some things that you may want to do when you're considering your patient portal is you may want to come up with certain types of parameters. So, for example, if the patient is ages 0 to 12, maybe you give the parents access to all the records. On the other hand, if the patient is age 12 to 17, the kind of an age gap where patients may be able to access their own information or may be able to consent to their own health care, in those situations you may want to limit parental or personal representative access to those records, particularly if the records concern women's health, psychiatry, substance abuse, or other situations for which the patient may consent to their own health care. Once the patient hits age 18 or over, then generally you're going to want to terminate parental access to the patient portal because the parent is no longer, you're going to want to terminate parental access to the patient portal because the parent is generally not the personal representative at that time. If you're going to continue to allow them to access it, you would generally need the patient's authorization or some other appropriate consent to allow the parent to continue to access the information through the patient portal. Well, what about third parties? Be careful about allowing third parties to access the patient's information through the patient portal. Generally, you're going to set it up so that only the patient can access it. You would want to warn the patient against allowing third parties to use that password to access. As a practical matter, the patient can allow anyone to access. You just need to put in place reasonable safeguards to limit unauthorized access. You generally cannot knowingly allow third-party access to the information unless you can fit within a HIPAA exception. Either you have a HIPAA-compliant authorization or the patient directs you to allow that third party to access the information. It may be family members or others involved in the patient's health care so long as the patient has agreed or has not objected and you otherwise determine it's reasonable under the circumstances, or if it's a personal representative. But the general rule is if you're going to allow third parties to access it, you've got to have a HIPAA exception that will allow them to do that. Some of the options for allowing third-party access through the patient portal are things like allowing the third party to use the patient's username and password, so you don't set up a separate account for them. You just simply allow them to use the patient's access information or their password. Of course, that may violate the security rules that require unique passwords. Another option is you give that third party their own username and password, but only do that if the patient agrees. Generally, you're going to want a patient HIPAA authorization. Might get by with that patient request to disclose the information so long as it's clear and the patient signs it. Another option is you could set up a separate account with different parameters. For example, allow that proxy or that third party to only access certain types of records. Just a word about breach reporting. If you do disclose the information improperly to a family member, that's probably going to be a reportable breach. If you have the unauthorized access, use, or disclosure of protected health information in violation of the privacy rule, you generally have an obligation to report that to the individual and the HHS unless you can determine that there's a low probability that the data has been compromised based on an evaluation of these 4 factors there. You already know about the breach test, so I don't need to get into that. All right, when it comes to dealing with family members, there's a bunch of information on the government's website. In fact, they have a specific guidance on the OCR's website dealing with family members and friends that covers these rules that I've talked about today. Among other things, they've given you a couple of guides, including these FAQs about communicating with family members and also the recent guidance concerning responses for opioid crisis and situations in which you may be able to disclose information in an opioid case. I think it also has broader application to any types of situations, and therefore it provides some helpful guidance. It's among those written materials that we provided to you. We've also got a lot of additional resources on our website, including additional webinars or a bunch of client alerts that I've written because I love HIPAA. Just a word about upcoming webinars. On July 26th, on just this Thursday, we've got another webinar coming up dealing with the new rules concerning association health plans. On August 9th, I'll be talking about HIPAA and 42 CFR Part 2, those federally assisted drug and alcohol treatment programs. On August 23rd, we'll be talking about healthcare mergers and acquisitions, should you have an interest. That is it. That is a brief overview of the rules for disclosing information to family members. Just to recap, you can disclose information if you're disclosing to personal representatives of the individual, to family members and others involved in the patient's health care, so long as the patient agreed or was given the chance to object and did not object, or if it's for treatment, payment, or healthcare operations, or to avert a serious and imminent threat of harm, for certain facility directory purposes. For most other purposes, you generally need either the patient's authorization or a written request from the patient to make that disclosure. I hope that's helpful. If you have any questions about anything we've talked about, you can submit those questions using that chat feature or just shoot me an email offline, and I'd go ahead and be happy to respond to that. And that concludes the webinar. I hope you guys all have a good day.